Hi, this is Mark Schroeder, Head of Client Relations at GSHC Surrogacy Agency, and today I'm speaking with attorney Robert Terenzio from Florida, who's going to tell us all about the legal process for surrogacy in that state. Robert, would you mind giving us a little background on yourself and your practice?
My name is Robert Terenzio. I'm an attorney licensed in Florida and in Connecticut. Our office prosecutes only assisted reproductive technology cases. We don't do anything else. I am a member of Florida and Connecticut bar associations and their family law associations as well. I'm a member of the American Bar Association and its Assisted Reproductive Technology Committee. I have a very strong sense that transparency is needed in ART, Assisted Reproductive Technology. As such, I have lectured pretty much all over the world to doctors, other lawyers, and certainly to the infertile public about reproductive technology and how it should be done. I'm a member also of Quad A, which is the American Association of Adoption Attorneys, where I am an ART fellow. And I'm a member of SEEDS, which is an ethical organization looking again for transparency in the industry. All of the organizations that I've been involved with, all of the lectures that I've given over the years, and all of the associations that I've made with other professionals have been to make these things as transparent as possible, as safe, both legally and financially as possible, and then to be able to deliver, no pun intended, a mechanism for that parent or parents to finally go home with the baby that they've been asking for years in some cases.
If an international lesbian couple comes to the United States for surrogacy, what are their options for establishing parentage?
We have had a number of lesbian couples, typically that are married, and typically where one will share her ova with her wife. And to cement the legal process and provide everybody assurances that parentage is equally shared, we will prosecute an adoption. We find that an adoption through the court has more legal security than an administrative process of just placing a wife on the birth certificate merely by virtue of the fact that they're married. So we would basically do a straight up adoption where the birth mother will advise the court about the delivery, about how she came to be pregnant, that she confirms her marriage to her wife, and the judge will look at the documentation generated by this office. The judge will make a determination if a home study is needed, and I'll go into that in 1 second. And then if everything follows Florida law, the court will generate an adoption order conferring equal parentage on both of the women, where they will share parentage, custody, control, and responsibility for their child equally.
You mentioned a home study a little earlier as part of the parentage process. Can you give us more details on what the home study would consist of?
Home studies inside of an adoption are always at the discretion of the court. Some judges feel very comfortable that by virtue of being married, you will not need to have a home study. I would say that's probably correct in 99% of the adoptions that we have prosecuted. And if we don't have to do a home study, it certainly saves the clients some money. And it allows us to get into the court a lot sooner. It's not uncommon for the timeline to get a home study done to be in the 90, maybe 120 days. If it's not required, if the judge will excuse it, we can typically get into court within 30 days of the date that we file the documents. Generally speaking, if we take a worst case scenario where we're going to need a home study, the home study is going to be about $2,500 US. It may be more if there is some external reason, but I would say that's probably a safe guess. The legal fees and costs for the law office to be involved is totaling about $4,000. And the first thing that will happen is the person doing the study is going to ask for financial records of some sort and for a medical history. Mm-hmm. In addition, they typically will do a local, meaning US FBI background check, and if possible, an Interpol background check. The best interest of the child means basically, can they afford what they're envisioning, and are they good people? Obviously, criminals are not necessarily good people, so we'll exclude those through the FBI and Interpol. And it's obvious that there are some countries that the FBI will not know anything about, and Interpol doesn't even go into. But those are the things that they'll rely on. So if those come up empty, then from the court's perspective, they have a clean background. And so that's that side of that particular transaction is done. The next thing will be something that you just referred to, and it's going to be an interview. And typically it's a few interviews with international clients, of course, and with clients from other states. They're always virtual.
And how is this process any different if the intended parents are not married?
If they're not married, then it becomes a different issue. In all likelihood, the judge will require a home study be done. Now, we have a number of social workers that we engage, all of whom are very experienced through working with the LGBT community and with adoptions arising out of a different assisted reproductive technology arrangements, be it sharing OVA or a surrogacy kind of arrangement. And so they understand what's going on already. And I think that makes it easier for the adopting couple, because the conversation is just going to be about them. How long have you been together? Tell us about your social life. Tell us about your work life. Tell us about your family life. And do you each feel comfortable that the other has a present ability to provide for the health, education, and welfare of the child? And do you each feel comfortable that that ability will extend into the future? And it's not these examinations are not graded. If you're honest, you pass. The judge ultimately only wants to look at the last sentence of the report. And the last sentence is, this couple is a loving couple who have an ability to share custody of a child in a way that we would expect any Florida couple to share custody of a child. And if that's in the document, that's the end of the conversation as far as the home study goes. Like every state, but unfortunately not every state, but like California, Florida is a very LGBT friendly community when it comes to adoption. So the fact that we're talking to, in this case, a lesbian couple, is not a factor at all. There's no need for people to feel uncomfortable because they feel that they might be looked down upon because of their living arrangement. It doesn't happen either in the court level, and most certainly not from the social workers that we engage to do these kinds of studies.
And what if you have a situation where two same-sex intended parents are both on the contract, but only one of them wants to be listed on the birth certificate? What happens in that situation?
The mechanism that we would employ would depend upon the reasoning behind wanting a single parent on the birth certificate. If it was something such as we've been talking about, an unfriendly country, all that I would do would be an addendum to the existing contract. And we do that quite often. The contract, it does a lot of things. The surrogacy contract, if we dilute it to its barest essence, it's making sure that everything that the parents want to occur, and everything that the surrogate would like to see happen. So from a legal standpoint, it's always better to have both parents on the surrogacy agreement. Consider trying to pay some of the medical bills. Instead of having a single person responsible, we now have the couple responsible for retiring all of the medical bills. But that contractual side doesn't mean that we're barred from having only one of the couple on a birth certificate. We can deal with that with an addendum, or at times we could deal with that internally in the contract itself by just saying something as simple as the home country of the intended parents will not permit both parents to be on the birth certificate. Therefore, the parties agree that Dad A will be the sole father listed on the birth certificate for the child born of this arrangement.
And will other U.S. states recognize a second parent adoption that was established in the state of Florida?
There is and we would call it a black letter law rule, which is adoptions have to be accepted by sister states. Adoptions basically trump everything when it comes to authority of who is and who is not a parent. So we have generated second parent adoptions here for years. We've never had any other state reject our adoption orders. And quite honestly, they can't reject them. They have to accept them. We're obviously in a very weird political frame of reference these days. Even the most conservative states accept the adoption orders and then turn the birth certificate from a single parent into both parents.
Robert, can your office work with international intended parents who are not based in Florida?
Most of our clientele at this time are not from Florida. Most of our clientele are international. I would say that 70% of our clients are from another country, and probably 80% of those folks are either single or part of an LGBT couple. We have ways of engaging the court's jurisdiction so that they can come here and feel comfortable that they're getting a court order. And most certainly, if you have a couple that is relying on a Florida surrogate and is expecting a delivery in Florida, Florida absolutely will attach jurisdiction. If it is not a scenario where there is a Florida delivery, there are other ways that we can engage jurisdiction such to be able to prosecute the adoption. And the best way that I could describe it without being very boring about all of the legal stuff is most of the jurisdictions that require folks to come to Florida are themselves unfriendly either to the fact that people are single and wanting to be parents, or that they're in an LGBT couple, or that the jurisdiction doesn't like surrogacy, or that a marriage, a same-sex marriage is not permitted there. And that discrimination, that discriminatory attitude opens up a number of avenues for judges in Florida to say, yes, I will listen to this petition and generate a parental order in favor of your clients.
And what are your legal costs for the entire surrogacy process, from contract phase up through parental rights?
This office breaks things into bits because surrogacy is a number of processes all strung together. So there is a contract bit, and then there is the legal work side. The contract bit, we charge $3,500 US to do. If we get past the time frame for miscarriage, if we're into the third trimester, we send out a second invoice for $3,000. And that invoice takes care of our involvement with the hospital, with the courts, with getting the pre and post-birth orders, and with obtaining the birth certificates for the parents. The only other items that have a dollar appended to them are the cost items. And those are things that require us to pay third parties for. As an example, UPS to get documents back and forth, the court filing fee, which is about $400, and then the cost of the birth certificates themselves. They're about $30 a piece. And then finally, for those jurisdictions that will require it, not all do, but some do, we take the birth certificates, send them to the Department of State where they can be apostilled. And those have a cost the Department of State will charge for those too. So the only other legal cost really is from the reviewing attorney who is representing the gestational carrier. And here in Florida anyways, the cost is approximately $1,500. That's a one-time fee, and while we've not talked about the review, when we generate a gestational surrogacy agreement, it's sent to the parents. We give them time to review it. We set up a Zoom, Skype, or other form of communication. If translation's needed, we take care of that too. We'll review it, answer any questions that the parents might have. If amendments or changes need to be made, we'll make them then. When the parents feel comfortable, we send it to the surrogate's attorney. As I said, that's about a $1,500 fee. The surrogate's attorney will review it with their client. If there are changes that are requested, I will get those. If they're material, we'll talk to the intended parents, our clients, another time to get their approval or declination of the changes that's being requested. And if everybody is feeling comfortable, everybody will sign. Of course, clients that are international are typically going to be signing by way of a virtual notary. And we have a virtual notary in our office. And when we have everybody's signatures, we send a clearance letter to the treating reproductive clinic so that they can start the clock on the calendar for the cycle.
This has been a conversation with attorney Robert Terenzio from the law offices of Robert T. Terenzio, located in Florida. Thank you very much for watching.
GSHC